Hello everyone, welcome to Cashcroft TV. My name is Kalen Ashcroft. Thank you very much for watching this video on Guide to Legal History and Historians, where we will be covering each and every chapter of the Oxford Handbook of Legal History, edited by Marcus D. Dubber and Christopher Tollins. Through the course of this series, we will be going through each chapter and respective biography of each respective author, as each chapter actually has a different author. And following each two pairs of chapters, we will also have comparisons of the two authors in the style of Plutarch's Lives and my other series. So in that way, we might learn a little bit more about the authors, or more importantly, or perhaps equally as importantly, to discover sort of their different potential academic tangents that one can take. So without further ado, this episode will be on Jewish law and Islamic law, so these must not be watched in order. So if you are particularly interested in Jewish law or Islamic law, or the works of Stephen Wilf or Lena Salaymeh respectively, this is for you, and I hope you watch some of the others, or if not all of the others of this series and all of my other videos as well. So without further ado, we will begin with Jewish Law by Stephen Wilf. So to discuss briefly the biography of Stephen Wilf that I've prepared, so he is the Anthony J. Smits Professor of Global Commerce and Professor of Law at the University of Connecticut School of Law. He's an expert on intellectual property, namely copyright and trademark, and as well historical jurisprudence and legal history, as evidenced by him being included in this very valuable textbook. He was born in Philadelphia, Pennsylvania, where I've spent some time, a great beautiful city, and he received his Juris Doctor and PhD in 1995 in history at Yale Law School and Yale University, respectively. He also clerked for the U.S. Court of Appeals Second Circuit, which covers the District of Connecticut, Eastern, Northern, Southern, Western districts of New York, as well as the District of Vermont. So a pretty exciting clerkship, and an appellate clerkship too, so very prestigious, if to be put bluntly. And he did this before joining the faculty at the University of Connecticut. He has been a visiting professor at the Hebrew University of Jerusalem, as well as the DADD guest professor at the Free University of Berlin. He most recently served as the Maurice Greenberg visiting professor at Yale Law School as well. From 2010 to 2011, he was the Microsoft Fellow in Law, Property, and Economic Organization of Society at the Princeton Program in Law and Public Affairs. And in 2013 to 2014, he was appointed the Elizabeth S. and Richard M. Cashin Fellow, the Radcliffe Institute for Advanced Studies at Harvard University. His other awards, to name a few, include that from the U.S. Copyright Office, the Abraham L. Kemmenstein Scholar in Residence at Harvard, a Fulbright Schumann Innovation Scholar at the Centre d'études internationales de la Propriété Intellectuelle in Strasbourg, as well as at the University of Chicago Fellow in Comparative Legal History. Some of his publications include he was the editor of the Intellectual Property Law and History in the University College London Law Review in 2011, Law's Imagined Republic, Popular Politics and Criminal Justice in Revolutionary America, which is published in the Invention of Legal Primitivism, the 10th Theoretical Inquiries of Law 485 in 2009, as well as The Law Before the Law, the Making of the Post-War Paradigm in American Intellectual Property Law, the 31st column, published in 2008, as well as 15 scholarly papers available, including well over 15 scholarly papers that I recommend reading, and he's currently completing a history of intellectual property law for the Cambridge University Press. And I also have some suggested readings on the slide as well. So we'll get to those as well. We'll discuss the slide after we discuss his chapter. So that's a brief biography of Stephen Wilf, a very important scholar representing many universities, and particularly in the New England area, but also has a lot of experience abroad. So without further ado, his chapter in the Oxford Handbook of Legal History, edited by Marcus D. Dubber and Christopher Tomlins, is in part 4 of the textbook, titled Traditions Tracing Legal History, and his chapter is chapter 39 of the textbook, and it is titled Jewish Law. So in terms of the introduction, he opens up with this quote, a quote by himself, of course, "Jewish law is often considered a law without an army or navy." And he cites that it fits within a vexed category of what has been called law without nations, where no coercive apparatus exists to enforce norms. Robert Covers, in his book Nomos and Narrative, famously celebrates this absence of coercion through prison and corporal punishment in a dysphoric Jewish law, and instead, in his romantic reading of the past, claimed that social cohesion created its normative sinews. So not those stronger forces that even we might have seen as we covered canon law often had. In contrast, proponents of deploying Jewish law as a grounding of modern Jewish state, such as the late Israel Supreme Court Justice Menachem Elon, have argued that throughout the diaspora until the 18th century, Jewish courts with significant policing power operated in the Christian and Islamic lands. So, contrary to common belief, there actually were often policing forces for the Jewish law up until the 18th century. According to Menachem Elon, Supreme Court Justice of Israel, one of two historiographical narratives are clearly at odds, so which is the correct one, and they share also a fundamental presumption. Jewish law is identified as autonomous, so whether or not it had a policing force or not, it is autonomous. So this is something that is still not entirely determined. I think it's probably somewhere in between. It did have, to some extent, some policing force at certain periods, and at some points, no policing force at other periods, perhaps. Well, that would be what I would gather. So he notes that this chapter will take the opposite approach. It will argue that Jewish law's distinctive nature is constructed from the ancient and modern period in the midst of a complex competing world of legal pluralism, and will examine how appropriated, resisted, and oddly conserved, sometimes while claiming as its own other forms of legalism, such as Roman or modern law, to create the impression of being legal other. So in complete contrast to this law being autonomous, he notes that it is part of a broader pluralism of laws, including, in some cases, even Roman and modern law. So it's not, Jewish law does not have defined boundaries, whether it does have a police force or not. Complex law spanning millennium, it is a complex law that spans millennia from biblical origins to the present, and it emerges from the creative centers from across the globe and is punctuated by a vast corpus juris, including monumental compilations and codes, some of which we will cover here, and includes over 300,000 known responsa, which are legal decisions as well. So it's a living body as well. And it's nearly impossible to characterize such a diverse legal tradition. So there's not just the Old Testament, as we're noting here, as I actually have a copy here, if I can reach for it. Here, it's probably not a good idea, but there's the Old Testament is the first part of the Holy Bible, or often called the Torah or such, or there are also many other historical writings, but there's also the living body as well, in that there's these responsa, which are legal decisions produced by the later Israel state, but also throughout the whole history of the Jewish people. One of the constants for over 2,000 years, he notes, has been the interaction with other legalities, which is probably the main point he would like to drive through with this chapter, that contributed to Jewish law's vitality through appropriation. And the influences and processes are not often clear, and law in general often assumes a conservative guise, but minorities operating in scattered, diasporic communities particularly vigilant about guarding its distinctiveness, rabbinic figures namely. So although many of these figures, rabbinic figures, did want to make Jewish law seem completely separate, it's impossible to conclude entirely, according to the author, that it is, in fact, has always been completely autonomous. The architects of Jewish legalism through the millennia prior to the modern period, and they policed the boundaries of the Jewish law by relying almost exclusively on internal precedent and carefully scrutinizing attempts to transplant norms from outside the traditional corpus of Jewish law. So the question of how Jewish law was constructed, was it primarily oral or written as seen in the Torah, or was it through case law or through codes, or was it directed towards judgments, or was it flexible, will be deduced to two trends. The stalled, perhaps even failed attempt to deploy Jewish law as a foundational legal system for the modern Israeli state, and secondly, the project of mining traditional Jewish law for its non-parochial, broadly conceptual jurisprudential principles. So he favors the latter, as we'll discuss in more detail shortly. Prior to embarking on a remarkable brief survey, this is him speaking, the author, Stephen Wilf, speaking here, of a long and complex legal history, a few preliminary points about scope are in order, so put these forward in the introduction. This chapter cannot aspire to being a comprehensive, and indeed remains almost impossible to follow the arc for the past 2,000 years, from seed time to Talmudic reasoning in late antiquity until the present. So he does not assume to be completely comprehensive. However, I believe he does a phenomenal job, as he notes remarkable in his words. Jewish law is notable for its claims to a continuous tradition lasting millennia, and its broad scope, including civil, criminal, family, and ceremonial law. But this chapter is directed to non-specialists in the field who are intrigued by legal structures of jurisprudential system that have had its beginnings outside Western legal culture, even though much of its past has been intimately entangled with Western law. So if you're looking for specifically family Jewish law, there's a place for that I'm sure one can seek out, or even if you're interested in a specific area, perhaps Stephen Wilf would be the one who might be able to direct you. This is to broadly track the trends across many different metrics, and also not to put it into the the rubric of the Western law traditions. For example, in the ancient Jewish law traditions, largely they were not divided in these specific areas, which came later, although there are notable distinctions in some of the works. Another few caveats. There much of Jewish legal history remains directed towards intellectual history, with only a few studies addressing the opposition of Jewish courts and law as a functioning system of law in its social setting. So largely directed towards intellectual setting and less on the practical, which would be the opposite of intellectual history, or also seen as social history is also another comparative. So I also have or through the Oxford Handbook of Legal History lectures as well on both intellectual history and social history, and as well law and society, or law_society, because it's not clear whether it's law or society, law with society, law in society, and the same can be said for all such combinations. And the focus of the chapter, therefore, is about the development of interpretive power of Jewish law and how that discourse has been shaped by its historical context. Jewish law, or halacha, as known in Hebrew, has been seen by its practitioners as a seamless conversation spanning generations and geographic locations, and the interpretive clout, in fact, rooted in the sharp debates of competing schools of legal analysis. And therefore, there's a combination of intellectual history and social history. And the second caveat is that the chapter begins only with the rise of the rabbinic legal discourse at the beginning of the Common Era. Of course, Jewish law is rooted in biblical law, and the statutes apply not only to communities in the broad biblical period from the emergence of the patriarchs through the establishment of a monarchy in the land of Israel, but also to exercise binding authority on contemporary halacha as a kind of foundational higher orders. So it's not going to specifically go into the before Common Era period, where if that is to be studied, it's probably best to go directly to the Old Testament. I think particularly And the Ten Commandments are important. I think the Book of Judges I find is very fascinating, at least not to go into too much of a tangent, but I find it interesting that the Book of Judges comes before the Book of Kings. So if thinking of Montesquieu's, I also have that, the Spirit of the Law. So I'm not going to keep grabbing my books every time I reference them, but there's the concept of the separation of the executive power and the judicial power, and as well as the legislative power. But at least in the Old Testament, the judicial power seems to come before the executive power. So that's a small tangent that I think is something to be thought about. But nevertheless, biblical laws, he notes, are often apodictic or absolutely mandatory injunctions, such as the commandments of the Decalogue, or caustic or causistic, which is case law that is conditioned upon a set of circumstances, such as goring an ox. And in both instances, legal norms are rarely justified. So although it's important to read the Old Testament, I think for anyone, even whether Jewish or not Jewish, I'm not from Jewish lineage, but I made sure to read the Old Testament before the New Testament. But nonetheless, there's less justification, as one might find in other, perhaps, Jewish works, so that will be not directly covered here, although some references will be made. And biblical law does not seem to have a highly developed autonomous field or system in any real sense of the word, he notes. And our inquiry thus begins with the rabbinic turn to interpretation, so sort of into the Common Era when we have these rabbis who are interpreting the Old Testament. Christine Hayes identified Jewish law as a constitutive, and he notes, constitutive of what? Abraham Joshua Herschel referred to it as pan-halachicism of Jewish law as a unifying force, but geographic metaphor for this chapter is that law is not an island. So although some scholars point to law's autonomy or law being an island, his, if anything can be taken away from this chapter, is that there's much overlap with other fields, and even there's no distinct boundary of what is Jewish law within itself. It is a borderland, porous site of appropriation and exchange, a liminal space positioned between one culture and another, and a boundary policed by those who seek to identify practices that stand in opposition to core Jewish legal norms, in sum, the locus of legal pluralism. The shifting of this interpretive frontier is the particular narrative of Jewish law that this chapter seeks to articulate. So therefore we're trying to discover constitutive or constituent, and of what, and what is it itself. So that's part of me for the longer introduction, but I think by going more detailed on the introduction, some of the other sections might be more clear, and we can perhaps go through them somewhat quicker. So moving to section 1, titled The Law of Significant Contention. So what is this contention? So he knows near the end of the Second Temple period, which is roughly 530 BC to AD 70, Jewish law emerged as a counterpoint to Roman imperium that relied upon local provisional elites for governance of a vast empire. Alternative forms of dispute resolution through courts grounded by indigenous legal traditions, such as Philo of Alexandria from 25 BC to AD 50, described Moses as a foundational legislator like Plato or Solon. Plato is, of course, a very important scholar that everyone should read. I think Plato's Republic, which is documenting the words of Socrates, was one of the first books on, I'd say, political philosophy that I read, and absolutely fascinating. And Solon, I also have a lecture on, as he's one of Plutarch's parallel lives. Solon is paired with Poplicola. Solon is from ancient Greece. And according to Philo of Alexandria, once again previously mentioned, Mosaic law is in harmony with nature and preserved through reverence of Jews, and unique insofar as preceded the formation of a state rather than created in the midst of political governance. So that's a very important thing to note, whereas many laws came after the establishment of a state. The state of Israel came, in many times did not even exist, but came after the laws. And as I mentioned earlier, that it's interesting that the book of Judges comes before the book of Kings. So before, although there were essentially leaders of the tribes of Israel for many occasions, before they ever had kings, they had judges. and judges led Israel, they're called it. To judge over Israel would be to lead over Israel. So I think that's something to think about. At least it's fascinating for me. The simultaneous legal debates in the 1st century AD in the Republic of Zeno, they had the Stoic ideal that law was universal and lived according to the basic common precepts of nature that fostered virtue. So Zeno of Citium, I also have a lecture on as well. Pharisees, a apolitical and religious movement appearing in this period, argued Jewish law embodied moral principles derived from divine origins. The cornerstone radical claim that oral law as an authoritative legal tradition parallel to written law contained in Scripture. So there's always this constant clash within Jewish law from even the earliest century AD between what is Jewish law. Is it that which the rabbis say, the spoken law, or is it only from the Talmud, and then who interprets it as well? Contrastingly, Sadducees and the followers of the Qumran, or the Dead Sea sect, denied the authority of unwritten sources. So we have these two groups, the Qumran and the Pharisees, who saw that Jewish law could be seen as written or only non-written or written, respectively. Sources: the Pharisees. So the Pharisees are those in favor of accepting the unwritten law, whereas Qumran were in favor of only the written law. Pharisees still insisted oral law could be traced to the revelation of the Sinai and transmission through Moses to the rabbinic figure as an unbroken chain, and it's been taught by masters since. And the emphasis on the oral tradition reflected the Greek notions that non-written law was superior to written contemporary because it was a living law and more flexible and reflected political wisdom. So there's two fascinating things here, is that the Pharisees make the argument that when Moses received the Ten Commandments from God on the Mount Sinai, it came from an oral tradition to begin with. So at its inception, it was oral to written. And then there's the second driving force, which is the Greek tradition that the oral law is more flexible than a written law. So there's these two forces driving the Pharisees, but the Qumran, the Dead Sea, focus more just on the written and sort of rejected some of the contemporaries who accepted the written, spoken oral law of many rabbis. They drew from the cultural heartland of Greco-Roman world, so this is where we're seeing this pluralism. It is deriving from Greek sources, such as Zeno, as previously mentioned, and from Zeno of Citium, that is, and judges wrap themselves in Jewish tayet, so a cloak with fringes serving as a mnemonic device of commandment. So even their clothing was similar to the judges in ancient Greek and Roman worlds. As Roman philosophers imitated Greeks by donning the pallium, the pallium is similar to the Jewish talit, and the legal discourse may also take place at meals resembling a symposium. So they discuss law in a similar fashion as in the symposium in ancient Greece, I believe that would be. And thus oral law as an equal to lex scripta, a radical assertion of authority, a kind of rewritten scripture, and was seen as such as Deuteronomy, which is or a second Torah. So this is Deuteronomy was one of the earliest books of the Old Testament, but it could be seen as a second development. But nonetheless, this new interpretations, this oral law, could be seen as a second Torah. Or the Book of Jubilees, seen as a second edition of a part of the existing biblical canon. So it's sort of, if the Torah can be extended, or even if Genesis could be extended upon, then why not extend upon the written law as well? In a sense, Jewish law was a series of second acts. So if you make the exception that for example, after Genesis, there's Exodus. If you accept that Exodus is an extension of Genesis, can you make the argument that there's no extensions beyond the Torah, or at least cannot accept written law? Perhaps the most impressive second act, he calls, is the act of of Mishnah, produced in AD 2000, and the name itself means repetition of law, which summarized the existing halasha in the period marked by the Great Revolt, which took place between 66 to 73 AD, the War of Kietas, circa AD 150, against Emperor Trajan, and Bar Kokhba rebellion in AD 132 to 135. So much political unrest, much wars, and many revolts, resulting in a long-term unraveling of Jewish presence in the land of Israel, and therefore it's called Oznamezzustand, which means emergency code, and therefore codification might have been seen as necessary. So they produced this Mishnah, which means repetition of laws. After so much turmoil, they thought they needed this codification. And therefore, it's something like, as we saw in my lecture on Roman law, the corpus juris of Justinian was produced not as an act of history, but as an act of preservation of what to preserve Roman law for future generations, and as to avoid them getting lost. They also provided a systemic ordering of the norms into 6 major categories, such as agricultural laws, holidays, family law, torts, and ritual law. So here we're starting to see these divisions of law as we see in the Western traditions. And it supplanted the Torah with a collection of clearly defined areas of law, with beauty of language and organization gained primacy in Jewish legal discourse. Therefore, it's composed in the Galilean hinterland of Jewish culture. The next Talmud came in the shadow of the Codex Theodosius in AD 438, and later came to be known as the Justinianus Juris Civilis in AD 534. Also included a variety of texts and moral rhetoric, suggested their role of a sort of legal archive preserving precedent, which included over 6,000 folio pages and had less precise language, and secured the Mishnah as the text scriptum. Many competing interpretations are subject to competing views and unending debates on constant squalls. So the next Talmud, which came about after we had this Mishnah, after the Mishnah came this next Talmud, but it wasn't as precise in language, and it was created in the shadow of the Justinian's Corpus Juris Civilis. So this one had much more criticism. Halasha as a hegemonic legalism emerged alongside an unquestionably legitimate, self-assured Roman law, and therefore became uneasy during the Geonic period from 589 to 1034 AD, as an attempt to reconstruct legal authority around Babylonian academies located in prosperous lands between Tigris and Euphrates regions of modern-day Iraq, or Geonim, meant pride and splendor, and since the Geonim means pride and splendor, and since the 19th century, genius in modern-day Hebrew. So Geonim were these leaders of these new schools of Judaism or Jewish law in modern-day Iraq. And the word literally means, or came to mean genius, which also has this concept of infinity as well. That's why they have the magic lamp, the genie magic lamp. It's a tiny place which comes out essentially infinity. The genie has 3 wishes, at least in Aladdin. The 2 presidents, and they refer to the 2 presidents of the academies, Sura and Pembedita. They relied upon the inheritance of the Babylonian Talmud for authority. So we have there was this Babylonian Talmud, and we also have what's called the Jerusalem Talmud. And therefore it's seen as the second Talmud. The Talmud of the land of Israel was first composed in strands from the variety of Galilean sources and incorporated more material on agricultural laws than the Babylonian counterpart. But the Tiberias of the Sea of Galilee was empirical epicenter addressed the claim of authority being on the land of Israel, and once the home of the major academy of Ar Yohan and Resh Lakish. So it's a question: why did the Babylonian Talmud become more popular than the Jerusalem Talmud? The Geonic turn led to the primacy of legal analysis, so these legal schools in Iraq focus more on legal analysis, and the two major academies, Sura and Pumbedita, formed in the Islamic Empire, cemented the link between legalism of the Babylonian Talmud and the flourishing seat of the authority of Geonim. The success of the Jews in Babylon exceeded those of Israel at the time. So that is basically the crux. There are two competing Talmuds. There was the Jerusalem Talmud, or the Talmud of the land of Israel, and the Babylonian Talmud. And one would think that the Jerusalem one would be more powerful because it's based in Jerusalem, the holy city for Jewish people. But because at the time there was much unrest and much difficulties in Jerusalem at the time, there was much more flourishing in Islamic land, and specifically these Geonims. So the Babylonian Talmud came to be the more accepted source of law at the time, and it focused less on agricultural laws than the Jerusalem Talmud. So lots of content here, lots to think about, but nonetheless there's sort of this, I guess it's an act of decentralization, but at least centralization within Babylon, but decentralization away from Jerusalem. The two important legal genres emerged during this Geonic period: responsa and halachic digests. The former, responsa, as mentioned previously, relies on legal queries from the entire Jewish diaspora, and they fully developed under Geonim as people would bring from Cairo pieces of law through scattered communities in the West. So people would literally carry with them legal decisions from Cairo and into the West. And he thinks one might imagine medieval merchants carrying these. So, for example, if they wanted to make a trade, they'll be like, you cannot beat me on this because I have a piece of law here, so I have evidence or such. And these halachic digests, and the latter, the halachic digests, were an innovation from the Geonic period as well, and they're akin to modern treaties, and they resembled contemporary Islamic mukhtasar of abridged legal manuals and individual non-particular legal writings. Therefore, the Babylonian Talmud still granted preeminence in the most famous Geonic academies. So, nonetheless, there was these halachic digests, which were sort of commentaries upon the Babylonian Talmuds, which also helped spread the law at the time. So that's why, I say that it's probably common sense, but if people are writing about a text more, that text by default becomes more popular and powerful. And perhaps the most famous Geonim, or one of these leaders of these schools, was named Saadia Gaon, who died in AD 942, drew from the Talmud of the land of Israel as well as a variety of Geonim legal traditions. So there's not complete separation. Even one of the most important Geonim of all time relied to some extent also on the Talmud of Jerusalem, and it's shaped by religious disputes, and led to the response to the emergence of the rapid growth of the Karaite movement that challenged the authority of oral law. So as seen previously, we again have a group that contests the authority of oral law. In this case, they're called the Karaite. The Karaites argued that the nature of oral law in the various forms implied divine law was imperfect. So if one could speak, then therefore something must have been wrong with the written law. Saadia argued, however, against this, in that the divine revelation at Sinai was revealed through the dual forms of the Torah, written and oral, at the same moment. So as I noted earlier, when Moses received the word of God at the Mount Sinai, it came originally from oral before he wrote it down. And this controversy between the Karaite and Rabbinic Jews was similarly could be seen as parallel to the fiqh debates in Muslim law over whether Quran or Pentateuch for rabbinic Jews could be separated to theoretical and methodological means of deriving legal rules. Therefore, the law is not just based on reason, but also just based on the text, or just based, and therefore there are also those such as ceremonial laws, which are not based on reason, but based on ceremony, based on tradition. Saadia shows a combination of philosophy and law, and written and unwritten rules are all important. In this regard, he took the first step towards sophisticated Jewish jurisprudence that would flourish in the Middle Ages. Moving to the next section, titled Codification and Localism. So following Saadia's footsteps, Ibrahim, a Jewish Aristotelian philosopher and apologetic historian, David Ibn Dawood in 1161, Iberian Jewish Aristotelian philosopher and apologetic historian David Ibn Dawood in 1161 completed Sefer HaKabbalah, which was responding to the Karaite critique by tracing an unbroken chain of legal tradition from Moses to his own day. So further building up on Saadi, David Ibn Dawood in 1161 traced directly a link between Moses to his own day. Therefore, if the chain was unbroken, therefore they can accept all these newer sources. And near the end, traced the story to 4 captives, and who were this is a kind of interesting story. So he traces this story to 4 captives who were Geonic scholars on their way to Torah study, who were captured by Muslims in the Mediterranean. 1 was lost, and 3 settled in Alexandria, Maghreb, and Cordoba, in each founding an academy. My computer's running low, one second. Sorry, foolish me, I didn't have my computer plugged in. So nonetheless, there were 4 Geonic scholars who were on their way to Torah study, and they were captured by Muslims in the Mediterranean. And 1 was lost. 3 settled, 1 settled in Alexandria, 1 settled in Maghreb, 1 settled in Cordoba, and each founded academy. So this is the Jewish people founding academies in Islamic territory. And the Cordoba scholar significantly was called R. Moses. So it could be true, could be not true, but the name Moses is definitely a significant one, and therefore the name itself suggested him being a progenitor of law. And he was also supposedly married into a prominent local family, so therefore linking this Jewish law with the Babylonian location. And he explained the rise of the Jewish law in Islamic territory. At the time, Cordoba was becoming autonomous Islamic cultural capital, separate from the caliphate control from the east as well. So there was the parallel autonomy of Jewish law and Islamic culture and Geonic academies and the caliphates. So there's also this trend that within Islamic territory there's this separation between, whereas Cordoba was not the capital of the Babylonian territory, was becoming the center of Islamic law. So therefore was also becoming the center of Jewish law, but both were relatively autonomous from their respective states, the caliphate or the state of Israel, or Jerusalem. And therefore there is this tension between codes and customary law, they're called antipodes. The legal literature of the Geonim itself demanded codification. The responsa as well were scattered and directed towards an immediate problem and not always collected for use by posterity. So many were lost, some were wrongly kept, and thus R. Isaac Alfasi from 1013 to 1103 was the head of the Iberian Academy at the time, created a quasi-code Sefer Halakot in the same structure as the Talmud, and the essay argues the Aristotelian and Neoplatonic systems imported from Arabic texts synergized with these works. So also under the dimensions of Greek orality, Roman codes, and Islamic responsa. So even this R. Isaac Alfasi, in attempt to once again codify is Jewish law, inevitably included Aristotelian, Neoplatonian, Greek, Roman, and Islamic ideas as well. So once again, there's this pluralism element. Moses Maimonides, who lived from 1134 to 35 to 1204, was religiously zealous Berbers from Africa. The Almohads conquered Cordoba in 1148 and effectively ended the Golden Age and threatened religious minorities. So therefore, Maimonides fled to southern Spain, later to Fez in North Africa, and then to Fusat, Egypt, and became the political leader of the Egyptian community and creator of the lucid Hebrew writing style, and he was also a polymath. He created the Mishnah Torah. So I mentioned in the introduction, one of the most important Jewish legal writings, probably only second to maybe the Torah itself, or the Babylonian Torah, and that perhaps a gesture of the composition of the Mishnah could be included 613 biblical commandments, 365 were negative precepts corresponding to the number of days in the year, and 248 were positive laws that reflect the number of limbs and organs. It is unclear if it is accepted in the Talmud as a normative principle, so it's not certain if this 613 can be justified through the Talmud, but nonetheless it became a successful rhetoric for embellishment. So by choosing this 613, 365 precepts and 248 positive laws, nonetheless it worked, at least from a marketing standpoint, if it is not true from the Talmud or the Torah. And the response to the imperfection of the historical vicissitudes was regardless of locality. So it was accepted because there were needed this sort of vicissitudes between different locations, and having traveled so much, there was clearly a need for some sort of consolidation. Others, such as the Ashkenazi, did not seek codes as substitutes, but instead sought to augment the Talmud with commentaries such as those of Rashi or Sholo Yizik of Troyes, who lived from 1040 to 1150, and two generations of medieval commentators from the 12th century, the middle and 15th century of Tosafot, often favored by merchants. So some of these merchants favored this, as well as the Ashkenazi Jews favored these sort of commentaries, perhaps because if they were more flexible, they might be more advantageous to their trade. They were seen as a river culture from York in England through the riverways of France to the Rhine Valley of Regensburg on the Danube to as far as East Prague, and favored contextualization of local legalism. So they also maybe favored it as well because there were deviations of laws. How did they deal with all these diverse people? And they deployed dialects as well, and therefore they noted custom trumps legislation, rather than their Spanish counterparts, who at the time were sort of less in favor of their localism. So that is sort of, and as this section is titled, codification codification and localism. So there's this contention between the codification, such as that work of Mishnah, and as well through the trading networks who favored localism. Much of this has also been lost as well due to anti-Semitism, such as in 1242, the Paris burning of the Talmud. Mark Alain Ukanin brilliantly argued that the burning of the Talmud returned work of the status of an oral text. So by burning the Talmud, it reinforced the necessity and the strength of oral texts, just as Christian contemporaries produced Tierce canon and Roman commentaries as marginalia, so did Jewish scholars of the Talmud. Yet with dissensions, as they were called by medieval Roman lawyers, sought to bridge contradictions, clashing Tosafists often highlighted their own disagreements with Rashi and with each other. Moving to the next section, so that is sort of broadly the clash between codification and localism. Moving to the next section titled Modernity and the Jewish Return to Legal History. So with the expulsion of Iberian Jewry from Spain in 1492 and the forced conversion of the Jews in Portugal in 1497, so much anti-Semitism at this time in the 15th century, new a new set of vicissitudes to return to the Maimonides phrase of disrupted legal transmission. So the Iberian Jews were separated in diverse lands, largely in Italy, North Africa, Turkey, and the Near East. Namely, Joseph Caro, a Spanish exile living in Salonika and later Safed, published a new code called the Shulchan Aruch, published in 1522. And unlike the Maimonidean code, included only religious, family, and ceremonial law. So it ignored the rich tradition of torts, contracts, property, and criminal law. So focused more on the, I suppose, the more cultural aspects rather than perhaps the commercial aspects. And maybe that might be something that could be seen as a common trend. The commercial aspects were harder to codify because of the necessity of different localizations, whereas the cultural aspects might have been easier to codify because they were less dependent on locality. And there was parallel division could be seen between canon and law and state law, and also seen in the movement of the Wissenschaft des Judentums by Abraham Greger, who sought to show law's imperfections arose from the fact that it was a historical artifact. So Orthodox Jewish legalists ironically adopted the German distaste for historical contingency and argued that Jewish law was a meta-historical construction, eternal and deeply logical, and applied Hegelian dialectics from Berlin, constructing analytical jurisprudence of the Halasha. In personam verse in rem is ripened, for example, is ripened grain movable or immovable property, so that's Latin. Personam verse in rem is, so an example of this is ripened grain movable or immovable property, because, for example, it's in the ground, but then when you take it out, you can move it. So is it immovable or movable property, essentially? And therefore, the increase in print allowed the dissemination of, as well, another force was that the increase in print allowed the dissemination beyond the elite. So there's this influences, ironically, he notes, from German influences such as Hegel, and such as the movement of property, but as well as print increased the dissemination beyond the elites. There were different needs of the population. And therefore, to address R. Israel Meir Kagan, published in 1902, Mishnah Brura, which was also narrower than the Maimonides, and directed towards addressing ceremonial or ritual matters as well. So, like the previous one, it also was focused more on cultural aspects rather than commercial, and the most notably embraced analytical jurisprudence of Orthodox Jews. On the other hand, Jewish nationalists, influenced by German Friedrich Karl von Savigny, believed that every nation must have its own laws. So, as discussed in many times previously, Karl von Savigny, very important in the clash between Germanic and Roman law in Rome, and therefore the Jewish nationalists were inspired by this and decided to have their own law as well. And in 1918, organized the revival of Jewish law was founded on the Moscow Mishpat Ivri, which was the name of the movement in the 1920s and 1930s, and increasingly directed efforts to construct civil law version of Jewish law, updated for modern circumstances and stripped of religious elements. And it was part of the broader movement of national rebirth, united under Zionism, but however, as might be noted, there was an evident pause during World War II after the Nazis of the foul things that they did towards the Jews at the time, and the longer idealization with the founding of a new state of Israel in 1948 and the shaping of the modern Hebrew language. So these things, although after the war things did sort of go back in their favor, there were still obviously many things that needed to be sorted out, such as the new Hebrew language, the modern Hebrew language. And in the late 20th century, they created a split between Orthodox Jews with the informal mechanisms enforced sanctions, largely emphasizing everyday religious life, and the Mishpat Ivri, who intended as official law backed by the state's power. So Orthodox Jews, surprisingly, did not think that the Jewish law should be backed by state power. However, the Mishpat Ivri did, and stripped of religious elements in seeking codification. The Mishpat Ivri were a historical failure, ultimately, according to Supreme Court Justice Aaron Barak of the Israeli Supreme Court, and Menachem Elon, mentioned previously, noting that Jewish law as a matter of last resort. So although Mishpat Ivri want to have Jewish law in all aspects of Israeli law, they note that Jewish law is ultimately a last resort. And Mishpat Ivri were less well adapted to new technologies, pluralism, and generations of feminism, gender fluidity, and heightened social interactions with non-Jewish neighbors. I think a parallel might be seen as constitutionalism in American law, as noted by one of, I'll have to memorize whom it was, but one of the most important United States Supreme Court's judges noted that the Constitution should be obviously applied and revered, but largely in a last resort. If it can be dealt with at lower courts or such, that would be ideal. Sort of similar, I think that Menachem Elon and Aaron Barak noted that Jewish law should be a last resort in the state of Israel, but nonetheless the ultimate law. And also it was less well adapted, as noted, to some of the modern trends, such as new technologies, pluralism, generations of feminism, gender fluidity, and heightened social interactions with non-Jewish neighbors. So moving to section 4, legalism becoming law. So the presumption for the contextual legal historians is that their task is to trace how law responds to social, economic, and political challenge, is in fact sometimes autonomous and sometimes more open, is permeable and appropriating. Law is so central to Jewish culture, he notes, from the biblical commandments from Mount Sinai to medieval commentators filling the margins of parchment manuscripts by the rivers of northern Europe, to utopian dreamers who hoped to perform the ultimate act of cultural alchemy in transmuting an ancient religious law into the mode of governance for a modern state that is taken for granted as a persistent and persuasive cornerstone. Yet this chapter tried to show Jewish law is in fact a shape-shifter. Every historian knows, as Bernard Schlink reminds us, that law's progress is a traveler's tale across time, where being capsized or captured like Odysseus is more likely than a peaceful journey home. What is important is that Jewish law is always trying to become law. It wants to be first cousins of Greek law in the heart. It wants to be settled as Roman code, as influential distant brethren, as Muslim fatwa, as rational as medieval notions of natural law, as useful as a French civil code, and as jurisprudentially clever as the rude Goldenberg constructions of German or American legal academic. Jewish law, in short, is above all wanting to be law. And then moving to this last quote, which I also have up on the screen. Indeed, the one constant thread weaving through the history of Jewish law is contention, and does not every difference render legible Jewish law as it might be, lex ferenda, rather than simply what it is. So I think quite a beautiful chapter. I hope I explained some of those many important works that Stephen Wilf documented in his chapter in the Oxford Handbook of Legal History. At least for me, it was very, very eye-opening, and it really helped combine many of the things that I have been studying, such as the Old Testament, for example, but also the Constitution of the United States, and as well as Islamic law, as we'll cover shortly. So thank you, Stephen Wilf, for your excellent work here. We will now discuss briefly his the slide I have produced here, and then we will talk more about the author in his comparison with Lena Salaymeh after covering her chapter. So his institution is the University of Connecticut School of Law. His position is the Anthony J. Smitz Professor of Global Governance. His expertise includes copyright, trademark, intellectual property, and legal history, and I would note specifically Jewish legal history is clearly an expert on that. In terms of the logos in the bottom right, we have Yale Law School, where he received his Juris Doctor. doctorate. And in the top right, we have the Yale University, where he received his PhD in history. And in the top left, we have the University of Connecticut, where he is a professor in the School of Law. In terms of suggested readings, we have Book 1, Patent Cultures, Diversity and Harmonization in Historical Perspective, which he wrote with Graham Goodey and is published by the Cambridge University Press in 2022. As well, The Law Before the Law, Law's Imagined Republic, Popular Politics and Criminal Justice in Revolutionary America, published by the Cambridge University Press in 2010. So clearly an expert also on American legal history too, or at least this sect. Once again, his chapter is in part 4 of the Oxford Handbook of Legal History, titled Traditions Tracing Legal History, and it is chapter 39, titled Jewish Law. And to the 3 quotes that I have collected here, I will briefly read them out. The first quote, Jewish law is often considered a law without an army or navy. It fits within the vexed category of what has been called law without nations, where there is no coercive apparatus to enforce norms. But as we discussed, that in times there have been, and times there haven't been. But that is the sort of the main thing that people discuss, but it was perhaps probably not the most important thing that people should be discussing. Next quote, Jewish law is a complex legal system spanning millennia from its biblical origins to the present, emerging from creative centers across the globe, punctuated by a vast corpus juris, including monumental compilations and codes, and including over 300,000 known respora, legal decisions. It is nearly impossible to characterize such a diverse legal tradition. That is quote 2. And moving to quote 3. Indeed, the one constant thread weaving through the history of Jewish law is contention, and does not every difference render legible Jewish law as it might be, lex ferenda, rather than simply what it is. So I think really quite a beautiful chapter, in my opinion, and thank you very much, Stephen Wilf, for really opening my eyes up in this area of scholarship. And now, moving to the next chapter by Lena Salaymeh. Her chapter is titled Historical Research on Islamic Law. It is also in part 4, Traditions Tracing Legal History, of the Oxford Handbook of Legal History, edited by Marcus D. Dubber and Christopher Tomlins. So a brief biography of Lena Salaymeh. She is the British Academy Global Professor in Oxford at the School of Global and Area Studies at the University of Oxford. I also see online that she is also a professor at the University of Tel Aviv. However, she may have recently switched over, or maybe she's a professor simultaneously, but nonetheless, I'll note them both here. And she's also a professor in the section des sciences religieuses at the École pratique des hautes études, and the Paris Science and Letters are also abbreviated as PSL, and she was previously in a visiting position there as well. She's the co-organizer of Decolonial Comparative Law project at the Max Planck Institute for Comparative and Private International Law in Hamburg. So the Max Planck Institute is a very notable institution for international law, but also particularly interdisciplinary law. She's the scholar of law and history with specializations in Islamic jurisprudence, Jewish jurisprudence, and critical theory. And her scholarship on law and religion brings together legal history and critiques of secularism. She received the Guggenheim Fellowship and her first book, The Beginnings of Islamic Law, Late Antique Islamicate Legal Traditions, received the American Academy of Religion Award for Excellence in the Study of Religion in the category of Textual Studies. So very significant achievement. She has also held visiting positions in addition to the PSL and Max Planck Institute, as well at Princeton University, the Davis Center, and the Department of History. And she received her Juris Doctor from Harvard and PhD in Legal and Islamic History from the University of California, Berkeley. She also has one edited book with Josef Schwartz and Galilei Shahar titled Der Orient, Imagination in Deutscher Sprache, published by the Tel Aviver Jurabuch für Deutsche Justiz, 45, published by the Minerva Institute for Deutsche Justiz at the University at Tel Aviv in 2017. As well, she has over 26 papers most recently, such as The Good Orientalists, in Westernists, Critical Reflections on the Spatio-Temporal Constructions of the West, edited by Christopher Gowilt, Holt Mayer, and Sergei Sigista, published by De Gruyter Oldenburg in Boston and Berlin in 2022. And with Ralph Michaels, wrote the Decolonial Comparative Law, A Conceptual Beginnings, published by the Rabelsgiefer für Aldensches und Internationales Privat, published by Rebels Z in 2022. So many significant writings and awards as well on her first book. So her title, Lena Salaymeh's chapter, is in part 4, Traditions Tracing Legal History in the Oxford Handbook of Legal History. It is chapter 40, and it is titled Historical Research on Islamic Law. So starting with section 1, the introduction, she notes at the time she was at, puts a little asterisk, at the time she was the associate professor at Tel Aviv School of Law, and she says, thanks for responding to my informal survey about historical research on Islamic law. And she thanks Guy Barak, Amar Osman, David Powers, Sher Ali Tareen, and Luke Yarbrough for comments on their piece. And she also thanks Guy Barak again, Rhiannon Graybill, Amar Osman again, Sher Ali Tareen again, and participants in the Tel Aviv Law Workshop for this work. So she starts off with this statement: Islamic law is not a self-evident category of analysis. Defining and understanding the category is a subject of both academic and popular debates, and it reflects a long history, more than 1,400 years, broad geographical expanse, and extensive demographic diversity of the Islamic legal tradition. Muslims, she notes, approximately 1.6 billion today, have understood and produced Islamic law in similar and changing ways throughout history. Nevertheless, conventional presumption that Islamic law is the result of Islamic legal hermeneutics, a branch of knowledge dealing with interpretation anchored in canonical Islamic scriptures and texts. In addition, less common presumption that the generation by an Islamic state, even when the state does not rely on Islamic legal hermeneutics, and thus there's this definition of Islamic jurisprudence as the former Muslim legalities, as the latter. So there's this belief that often there's this sort of Islamophobic belief that Islamic law is inseparable from the Islamic state and vice versa. But this chapter will suggest ways to reconcile these differences and variety of subjects and methods to contribute to defining Islamic law today. So largely so to contrast these widely held beliefs. And it centers on historical research about Islamic law and the Western Academy, which has increasingly significantly in recent years concentrated on contemporary scholarship in English, though also relied on somewhat outdated surveys and scholarship of German and Spanish. The dynamics of her work was specifically focused on how the Western Academy has been receiving Islamic law, and she follows through a contemporary survey of English predominantly as well as German and Spanish scholarship. The dynamics motivating historical legal research on Islamic law in the Muslim world are beyond the scope of this chapter. So this is how the West has been receiving. This is a Western book, how the West has been receiving Islamic law. Although a broad survey will emphasize key political questions and methodological conundrums that frame this body of scholarship, moreover, she notes it is not comprehensive. Scholarship on the early, modern, and modern histories of Islamic law and scholarship on Islamic legal history are outside the Arab world are underrepresented. And therefore, it's, once again, the Western Academy viewing the Arab world, but in her documentation of the early modern and modern histories of Islamic law, it will focus on within the Arab world. So kind of two forces going on here. Nonetheless, we start off with section 2, titled Political Dynamics. So what are these political dynamics that are shaping the Western reception of Islamic law? So while she notes, while there are multiple motivations for historical research on Islamic law, the Western Academy political dynamics deserve particular attention, namely the incorrect assumption that Westerners are in civilized conflict with Muslims has shaped Islamic law. She notes this is often anti-Muslim propaganda. And she differentiates between Sharia and Sharia law, and in Arabic terms, Sharia, which means divine law, and fiqh, which is juristic interpretations of divine law. So there's a difference between Islamic law itself and the interpretations of Islamic law. Islamic law, she notes, includes the fiqh. So for the purpose of this chapter, when we refer to Islamic law, we're referring also to the interpretations. Edward Said's Orientalism, a very famous book, receives these critiques, and Islamophobia has shaped much of the research in Islamic law in the West. First, she notes, because Westerns celebrate liberalism as a superior ideology, identifying or negating the presumed illiberalism of Islamic law is common preoccupation of historical scholarship. So this is sort of glorification, firstly, of the presumption that liberalism is always best, but also this assumption that Islamic law is anti-liberal. And thus, contemporary Islamic law scholarship, anachronistically, which means belonging to a different period, investigates modern liberal notions including freedom, rights, and equality. Much focuses on socio-legal concepts and modern discourse. Human, anima, environmental, gender, minority, and LGBTQ are excluded. So she notes this important word, anachronistically, which means from a different period. So to compare our modern conceptions of liberalism with some ancient conceptions of Islamic law would be unfair. It's like comparing Christianity on the basis of some poor canon laws in modernity. Second political force, because Westerners celebrate modern nation-state and liberal democracies as the ideal form of government, important themes of research are Islamic governance and codification, or modernization of Islamic law. So therefore, there's this prevailing assumption is that pre-modern Islamic states could not have developed under or nurtured modern liberal nation-states. So because the West created these supposedly superior modern nation-states before the Arab world or the Islamic world, there's this assumption that it would not have developed under Islamic law, which is a fallacy, likely. And third, she notes, because Westerners perceive the rule of law as limiting violence, much contemporary scholarship on Islamic law scrutinizes ostensibly harsh criminal or warfare laws. So they are perhaps harsher on criminal or warfare laws. However, this historical normativity is effaced in Islamic law with implicit tendency to compare Islamic legal history with idealized notions about contemporary Western law. So sort of this idealization of Western law and sort of overly critical of older periods of Islamic law. So I would also use this word anachronistically here again. And the fourth element is that because Western capitalism presumed to explain the West's ascendance, many studies of Islamic legal history investigate property relations, especially trusts, and some commercial laws presume to have limited capital developments in the world. So this sort of obsession with capitalism has criticized specifically the Muslim world on its property relations, especially on trusts, and therefore have used this as an element to criticize why the limited capital development in the Muslim world. But as we're seeing, there seems to be much development in the Arab world now, or the Muslim world. Fifth, because, and I should pardon me for using the Arab world, because the Muslim world expands beyond the Arab world and not everywhere within the Arab world as well. So my apologies for that. And fifth, because Western law understands uncritically as secular, much scholarship on Islamic legal history emphasizes its religious dimensions, despite the anachronism of applying the notion of religion to pre-modern history. Therefore, religion is not a transhistorical category, but rather the modern construct of secularism. So, historically, there wasn't really a separation between Islamic law. There's just the laws is governing Islamic people, but before secularism, there wasn't really this distinction. So because the West perceives their laws as secularism, by default, they only focus on the religious aspects of Islamic law. And therefore, religion has no clear meaning. Is Protestant, for example, I pose, is Protestantism in all common law, or is Catholicism in all civil law? Which would obviously be a fallacy. One would not go and criticize the French Civil Code by criticizing it on Catholic dimensions, and one would not necessarily criticize common law on Protestant grounds, although perhaps Montesquieu might think that would be a good place to start, and it's not entirely lacking of fruit. It's not the only way of analyzing it. And therefore they are interrelated and broad contemporary notions of liberalism, democracy, rule of law, capitalism, and secularism often skew historical legal research on Islamic law by projecting anachronistic concepts. So those are the main political elements driving it. And as we'll see, they've been different across different periods of time. So now we'll go through an overview of contemporary historical research, starting from late antiquity from 610 to 800 AD, to the medieval period from 800 to 1500 AD, to the early modern period from circa 1500 to 1800 AD, to the modern period, 1800 to the 1950 AD. So as we'll see, there's been different forces that have been driving scholarship in all these periods. So she notes, although Islamic law commonly viewed as a historical relic, predominant methods for researching Islamic law are not historical. For the most part, Islamic legal history conducted from the perspective of textual studies, so the most prominent would be textual studies. However, it's grown, it's ebbed and flowed over time, typically Near Eastern studies, social history, anthropology, or political science, depending on the period of study, have also become prominent as well. Generally, she notes, textual studies dominate the late antique and medieval historiography, social history dominates early modern historiography, and anthropology and political science dominate modern historiography. So there's no one brushstroke that covers all those. Perhaps I'm hoping that using that phrase right. There's been different trends throughout these different periods of historiography, and prominence of a particular discipline within each period reflects who specialized in each period, who usually received a similar disciplinary trainings in the Western Academy. In turn, the prevalence of the certain periods tend to frame with limited set of questions, and therefore in what follows is a rough, brief, and chronological overview of Islamic legal history and corresponding scholarship. So I think you have fun on this quick journey that we will go on. I certainly did. It's a really great overview of sort of not only the history of Islamic law, but how Islamic law has been perceived by outsiders and insiders as well. So starting with a late antique period from 610 to 800 AD. So this encompasses the beginning of the Islamic movement up to approximately the beginning of the 9th century, where the Prophet and legal and political successors administered Islamic law, simultaneously drawing upon contemporary regional traditions and articulating new legal perspectives. This fused pre-Islamic traditions with Islamic ones, and jurists generally adopted one or a combination of two approaches. Firstly, the rationalist approach anchored jurisprudence in logical thinking, and the traditionalist approach anchored jurisprudence in sacred textual sources. It was legally heterodox as a wide variety of approaches to Islamic law existed, but the area of scholarship expanded significantly in recent years as scholars have dedicated monographs to first centuries of Islamic legal history, namely source criticisms. So an emphasis on origins and foundational as superior, and comparing which source is older or more authentic. So when Westerners look at this late antique period, it's not really reading the content of the laws. It's like which is older, which is more accurate. And therefore it's also microtextual translations and summaries rather than macrocontextual and relational analysis, and suggests that late antique historiography should focus on Islamic law beyond text and read more critically and contextually. So when Western scholars look at this period, they really focus predominantly on the texts themselves, and they're sort of a micro analysis rather than a macro analysis, not the whole picture, whereas that might change as we get into more recent times, into focusing more on political and social forces. So then move into the medieval period. So how are these perceived by modern legal scholars? Medieval period from 800 to 1500 AD. So in the medieval era, Muslims jurists became professionalized, paralleling the Abbasid Empire's development of an increasingly more complex bureaucratic system. Muslim jurists debated the role of oral law and the combination of challenges to authority of oral reports and increasing availability and accessibility of writing led to intensifying importance of the recorded tradition reports called ahadith, and other textual sources, and gradually differentiated historical and legal genres as juristic profession became more specialized. Therefore, hundreds of legal scholars of thought consolidated and disappeared, leaving only several orthodox legal scholars. This canonization of legal texts coincided with the consolidation of legal orthodoxy. Therefore, during the medieval period, Islamic legal orthodoxy coalesced. And whereas in the late antique historiography generally focuses on the origins of Islamic law, medieval is concerned with the origins of orthodox Islamic jurisprudential methodology. Usul al-fiqh is called, associated with foundational texts or scholars. Just as Islamic law does not have origins, Orthodox Islamic jurisprudence does not have origins. So she notes that in the late end, there is no absolute origin of the first text, the Quran, because it came from previous sources, so you cannot just start there. But same thing can be applied to the Orthodox legal scholars. There is no definite beginning of that as well, for them. The medieval again, the textual studies direct towards close reading of dislocated and socio-political and historical surroundings. So once again, textual studies sort of characterize this medieval period. Medieval legal histories that institute Islamic law within various social-political surroundings are relatively rare. Historically situated comparisons with medieval non-Islamic legal traditions would be very productive. So when they do look at the context, it's only within the Islamic context, and they do not look at the surrounding environment. So for example, one might read one of these texts and think it is quite perhaps harsh or something, but what might be happening outside the Islamic world might be even worse. So they should be seen collectively. And some have occurred on occasion, but interdisciplinary approach remains infrequent. Some reveal nuances in legal education, but the unintended consequences of minimizing non-Orthodox schools and the role of the state have led to primacy. Colleges, centers, and education and political activity have been the focus and not the state, so the political aspects have been neglected in this period. It's sort of just the academic process of uncovering what the Orthodox legal school was looking at, and not only the loci of legal activity. So that we have to also look at the state. So whereas modernity, in the modern period, they might focus too much on the state, in this period it's largely neglected. So how did the state shape these texts? Farhat Ziada notes much scholarship neglects procedural rules essential to upholding justice. Likewise, texts of juristic disagreement, ikhtilaf, have not been thoroughly researched. Several important studies dedicated to Mamluk legal history have been focused but remained under-researched. In addition, geographic range of medieval Islamic legal history remains quite limited. So once again, with the late antique period, the medieval period also was focused overly on textualism and not contextualism as well. So moving to the early modern period and how this is analyzed by modern Western scholars from circa 1500 to 800 AD. The author, Lena Salaymeh, pardon me, it's a difficult name for me to pronounce, but I'm getting it, my apologies, Dr. Lena Salaymeh. She notes The author notes the state practices and bureaucracies both expanded and unified the dominance of Islamic law in the early modern era. Whereas previous empires permitted multiple legal scholars to coexist in many localities, the Ottoman courts became the primary venues for litigation throughout the Ottoman Empire. And during this period, they became intimately involved in every aspect of judicial activity, from training jurists and court personnel to selecting judges to promulgating legal codes. Similarly, Aurangzeb, the Mughal emperor of India, also ordered the compilation of Islamic law in a compendium based on authoritative legal opinions of the Hanafi school known as the Al-Fatawa al-Maghriya, which was compiled between 1664 and 1672. So in the Mughal Empire, there was also this consolidation of power, but most scholarship in this early modern period, as the author will note, focuses predominantly on the Ottoman Empire. And the important reference work throughout the South Asia and beyond for generations were influenced by this Mughal Empire. The Ottomans designated the Hanafi legal school as the empire's official school and appointed a chief jurist and established law schools in areas they conquered. As a result, law students began to migrate away from other Islamic legal schools as a step towards a career in the Ottoman bureaucracy. So as we see more common in common law academic institutions, as noted by our editor here, Marcus D. Dubber, it seems that in the Ottoman Empire it was common for, and also as we saw in Alexis de Tocqueville's Democracy in America, that lawyers often lead the political class. This was at least true in the Ottoman Empire, but although there was some heterodoxy in the antique and medieval periods, during the early modern period, a lot of people gravitated towards the Ottoman perceptions of Islamic law as a way to climb politically. The early modern Islamic historiography, dominated by studies of Ottoman court records and Islamic history under the Mughal Empire and Safavid dynasty, are understudied. So the Mughal Empire was from 1526 to 1540, as well from 1555 to 1857, and the Safavid dynasty was from 1501 to 1736. But nonetheless, these are understudied relative to Ottoman legal history, or specifically court records. Historiography is rarely comparative and infrequently situates Ottoman law within global trends. So it's just a so-called sort of narrow focus on Ottoman law. It's focused on archival records, which are often used for social history, and legal decrees of Ottoman jurists and juristic networks are unstudied as well, so even the texts here are neglected, such as the decrees of jurists and the juristic networks are understudied, more focused on the focal points. Nevertheless, Ottoman historiography made an important contributions to Islamic legal historiography by refuting stereotypes about Islamic law, by highlighting the role of the state and non-state groups in shaping Islamic law. So it must be, whereas the antique, late antique and medieval periods focused on, neglected the significance of the state, the Ottoman law maybe focuses too much on, or certainly does focus on the state and outside forces on shaping Islamic law. It's instrumental in refuting what Max Weber's stereotype of cadijustas, which caricatures Islamic law as irrational, arbitrary legal system and the antithesis of liberal and predictable modern secular law. So it's not that the Islamic law is necessarily such, but the state implied upon Islamic law in this way. And it illustrates judges followed well-known procedural and substantive rules of the states. So it's clear that the judges were following state laws more so than the direct word from the Quran, for example. They also helped overturn the stereotype that the Ottoman state was despotic, and that numerous studies demonstrate a combination of tradition and bureaucracy prevented a sultan from indiscriminately using his power. So it actually revealed something about the limitations of power of the sultan. Sultan Salaymeh, from 1465 to 1520, was known as a lawgiver, acquired the reputation for justice by punishing Ottoman administrators who had abused their power as well. Ottoman legal historiography has contributed significantly to complicating the oversimplification that Islamic law is jurist's law. So it's not just the jurist law, but evidently also has been affected by the states. But it is not the state, and as we'll see, there should be some separation there as well. Moving now to the modern period from 1800 to 1950. So in the modern era, the transition from empires to nation-states transformed Islamic law. The Ottoman Empire initiated reforms such as the Tanzimat reorganization in the 19th century. The Gülen Rescit in 1839 confirmed the civil and economic rights of all Ottoman subjects while endorsing Islamic law as the source of Ottoman law. And it promulgated multiple legal codes that were implemented by state courts, Nizamiya, and after 1869 the Ottoman Empire followed a civil code known as the Meseli Akam-i Adli, or the Ottoman Civil Code, structured like the French Civil Code, which integrated Islamic legal principles in a variety of Islamic substantive and procedural laws. After the Sykes-Picot Agreement in 1916, post-World War II, the British and French enacted the division of the Ottoman Empire into colonies. So, this is during the middle of World War I, the 1914 to 1918. There was the Sykes-Picot Agreement, which essentially divided the Ottoman Empire. And therefore, they applied colonial administrator handbooks or legal guides about Islamic law that had long-lasting influence. So there's also this outside force affecting upon Islamic law. And there were post-colonial Muslim-majority states established hybrid legal systems largely based on colonial law. So although the Ottoman law sort of peaked at this civil code, sort of shattered during World War I with the Sykes-Picot Agreement. And modern historiographies of Islamic law concentrate on Ottoman legal reform movement, colonialism, and codification transformed Islamic law, so therefore it focuses on this political and anthropological forces, and it traces the disintegration, establishment of colonial regimes, and later founding of a quasi-independent nation states, largely neglect the Mughal Empire, and colonial officers and scholars played a key role in promoting the notion that Islamic legal texts differed from Islamic legal practices, and it seeks to fill the gap between theory and practice in historical texts and relatively less scholarly attention to Islamic law beyond the nation state. So although it's important that they're now focusing on the political aspects even more, or they perhaps focus too much so, and less scholarly attention is paid beyond the modern nation state. Much focuses on top-down codifications, so as we've seen, social historiography would be bottom-up, political is top-down, codifications and legal reforms of Islamic law within particular states, without exploring the bottom-up production of Islamic law thought in those areas. Therefore, as we've seen, I have a lecture on social legal history and as well on political legal history, which I hope you might watch or listen to, and the modern legal historiography would benefit more explicitly from comparative and contextual studies that place Islamic legal practice within regional socio-economic transformation. So also other trends, not just the political trends. Doing so would clarify the complex and diverse processes and how legal discourses and practices were transformed in the transition from the early modern empires into modern nation states. So those are that's the history of how history has been analyzed within Islamic law. Moving to section 4, an agenda for future scholarship. So she notes Lena Salaymeh, pardon me. She notes, in summarizing Islamic legal history and legal historiography, previous sections sought to illustrate two primary challenges for historical research on Islamic law, and therefore it's important to avoid anachronistic historical questions and adopt a broader range of methods in order to ask different kinds of historical questions. And because Islamic legal historiography tends to be insular and overly technical, it is important for future scholarship to engage with theoretical debates in law, history, religious studies, and critical theory. And therefore, we will offer, or she, the author, the doctor, will offer some suggestions for future Islamic law, though do not encompass the temporal or geographical breadth of Islamic legal studies. So section A, terms and concepts. So terms, she notes the terms of Islamic law such as Sharia, divine law, and fiqh, as mentioned previously, which is juristic interpretation of divine law, need to be explicitly separated particularly. And how to define law underlies the late antique historical date on Islamic law's beginning. So also the terms, firstly, clarified that there is no definite origin, and is also defined divine law from interpretations of divine law. The author also notes, since scholars often project narrow or inaccurate definitions of law on the historical record, in modern historiography, who initiated orthodox Islamic jurisprudence, usul al-fiqh, revolves around what constitutes a jurisprudential text. So what is a jurisprudential text as well must be defined as a term, and this must be distinguished as well. Early modern legal historiography often preoccupied with defining Ottoman law in relation or opposing to Islamic law, and rigorous definitions of law must be made. So that's the terms, suggestions. And in terms of concepts, the role of the state should be greater studied in the late antique period, while medieval period and others such as the Umayyad law, Abbasid law, Fatimid law, or Milak law should receive greater focus as well. So these are concepts that could be focused on. Substantive reasons for why we use state-based legal categories should be determined. Additionally, analytic category of Islamic administrative law has been unexplored, and while contemporary questions of Islamic statehood have been addressed in modern period, more engagement with Islamic political thought and political theory needed, perhaps more so in the late antique and medieval periods. Lastly, separation between the category of religion and law need to be separated as secular and non-secular. Secularism is not a neutral or objective opposite of religion. Instead, it constructs a category of religion in various ways depending on specific location and subject. So therefore, the concept of focusing not by separating secularism and Islamic law, but realize that they are sort of cannot ever be entirely separated. And specifically to look at how secular nation-state define, transform, and obscure Islamic law to suit their purposes, an important topic of research that depends on historical understanding. So look at how these secular states are shaping the research surrounding Islamic law. Next section, section B, in terms of suggestions, global and regional legal histories. The author, Lena Salaymeh, notes, historical research on Islamic law would benefit from correlating Islamic legal practices to corresponding practices in global legal traditions. Notes that discover patterns of historical shifts that would otherwise be indiscernible, such as Islamic slavery laws would profit from comparative engagement with scholarship on the Islamic slave trade. So I think that is a very understudied area, but let's look at these parallel histories from a global perspective. Were there any parallels during the Atlantic slave trade and Islamic slavery laws? Regional trends are important too. For example, scholarship of late antique and medieval eras benefited by examining relationships between Byzantine, Sassanian, Rabbinic Jewish, and Islamic legal traditions. However, much focused on derivative linear connections. Horizontal analyses have been less frequent, yet would be more illuminating. 3 potentially significant areas of historical intersection between Islamic and regional non-Islamic legal traditions are relationship between oral and written legal traditions, the systematization of jurisprudence, and the canonization of legal texts. For early modern and modern eras would be especially benefited to situate Ottoman law in relationship to Mughal and Safavid law, as mentioned previously, and collaborative scholarship would be highly productive in this area, she notes. Global and regional legal historiographies may contribute to necessary task of decentrating the Arab world from the Islamic legal historiography. So may need to separate the Arab world from the center of Islamic legal historiography. And too much presently ignores Islamic law in the geographic areas presumed to be peripheral, such as Indonesia or parts of sub-Saharan Africa. So those are suggestions in terms of global and regional legal histories, which are all, I think, would be fascinating for any historians or those interested in Islamic law or religious law generally. Moving to suggestion C, materiality and book history. Traditional paperology, or study of papyrus, and numismatics, study of currency, have contributed to historiography through the advanced problematic dichotomization between documentary and narrative sources. So this was a lot of terminology for me, so I had to look up what it really is, the difference between documentary and narrative. So I saw Martin Scorsese actually had a good explanation, and that narrative are prescribed, pre-scripted movies with actors are narratives, whereas documentaries are capturing reality after the shooting has begun. So therefore, by moving beyond the dichotomy and assumptions embedded within it, so perhaps combine the two, textual studies would benefit greatly, specifically critical philology, critical bibliography, and book historiography integrate close textual analysis with anti-positivist orientation and with theoretical engagement. Therefore, context and content must be included, and moreover does not integrate fully factors related to materiality, including the production of manuscripts, introduction of paper, changes in cost of scribal work, and implications of printing. So I think many important things here to look and further contextualizing the text. Particularly, I think one of the most important noted here is changes in the cost of scribal work. So perhaps oral traditions were necessary at points because the costs were too high, or perhaps it was kept to the elites, who obviously have different preferences from non-elites due to costs of scribal work. Moving to section D, multidisciplinarity and theory. Some Islamic legal history scholars specialize in particular areas of law, criminal or family law. Nevertheless, deeper specialization coupled with methodological variety and theoretical engagement would enhance scholarship in the field. For example, medieval Islamic international law should not investigate comparative international legal history only, but also legal theory and political theory. Islamic trust scholars would be more enriched by more in-depth study of legal and economic theory with comparative analyses. Islamic legal ethics, particularly bioethics, would yield interesting results in incorporating comparative theoretical work, and the need to dislocate close reading of oral texts from the dominant position to open up possibilities for Islamic law to be a site for investigating historical and theoretical questions of importance outside the field. So a movement towards interdisciplinarity, the author's argument, would strengthen the specialization, which I think is true, and I think that applies even beyond just Islamic legal history, but into almost any other field. I think there's a common notion that one can get only better at some such thing by studying only that, but I think by studying other things, there's always synergistic effects that make one better at one's own specialization. Acutely important area of research, the author, Lena Salaymeh, notes is that the under-historicized and under-theorized is gender and sexuality. Exists the study of women's sexuality and legal history, but not a comparative or theoretically engaged. Not only Muslim women in historical periods, the current status, ahistorical and decontextualized, contributing to problematic ideological projects, especially imperialism. Woman is universal, transhistorical, must recognize nuances and varieties of women's experiences, critical feminist theories, queer theories, and other disempowered groups. So once again, this also falls into this interdisciplinarity concept that by studying these areas, hopefully some scholars might learn more about their specialization. So perhaps maybe in family law, they might learn more by studying some detailed studies of sexuality, for example. Moving to section E, then there will be F, and then we'll have the conclusion. So we're almost there. Thank you very much for making it this far. I know this is quite a lot of information, but I hope you appreciate it, and I hope you are enjoying it so far. So the section E, into interrogating orthodox narratives of Islamic legal history. So how Islamic sources composed Islamic legal history has not been a subject of critical scrutiny. For example, how did medieval scholars narrate late antique Islamic legal history, or modern scholars narrate late antique and medieval Islamic legal history, has been under focus, and therefore stories Muslim scholars of the past told about the past of Islamic legal tradition deserves more detailed scrutiny and critical engagement. Sociology of religion and critical theory would provide important tools for these investigations. So this is to kind of sum this up, interrogating orthodox narratives of Islamic legal history. So we've discussed how the Western Academy has viewed these different time periods, but how have these time periods viewed themselves would be important to note. Or, for example, how did the medieval historians view the late antique period, or that might apply across any back viewing period. Moving to section F, and the last suggestions, Islamic legal history in contemporary controversies. How contemporary Muslim movements and actors employ Islamic legal history is a promising area of future research. For example, after the 2010/11 Arab uprisings, how did figures, contemporary jurists, pseudo-jurists, and activists use Islamic legal history to justify or delegitimize popular uprisings? How did actors or activists fashion Islamic legal history? Anti-imperial and anti-colonial movements across the Muslim world mine Islamic legal history for precedents and justifications of their activities, while the state and non-state actors turn to Islamic precedents to condemn or justify the use of violence. So how Islamic legal history has been used in current trends to justify or delegitimize certain actions. Important areas of study, and I think perhaps maybe one of the most important, in fact. So, the conclusion by this great author. This chapter provides a partial sketch of Islamic legal historiography in the West, with modest suggestions for the future. It is a burgeoning field facing many political and normative challenges of scholarship in the Islamic studies more generally. But it would behoove this field to confront these challenges more directly, both by acknowledging them and recognizing how they influence contemporary writings of historiography. It's important to resist allowing contemporary politics dictate the border and content of research. And with a wide array of sources and questions not yet investigated thoroughly, the field will continue to grow and transform in unpredictable ways. Adopting more interdisciplinary methods and integrating more comparative and theoretical approaches will greatly enrich the field. So that was an excellent chapter by Dr. Lena Salaymeh, and I learned a lot about this, and I hope you learned a lot about Islamic law. As noted, this is how the West has been viewing Islamic law, so I think the best way to study Islamic law would be to read the Quran. At least started personally. I admit I have not completed the Quran. I have a copy of the Quran. I bought it in a nice old bookshop in Toronto, but there was a page missing, and my OCD sort of had freaked out, and I have to get a new copy essentially, and I couldn't continue with a missing page. So, but I endeavored to do this, but I also have to finish also the entire Old Testament as well. So, but nonetheless, a very fascinating area of scholarship, and I appreciate Lena Salaymeh for giving me this great introduction of how it has been viewed over time. So, to discuss the content of the slide before we will talk more about Dr. Salaymeh in the comparison with Dr. Wilf, we have her institution is the University of Oxford. Also could be the Tel Aviv University. Another website says she's a professor there as well, but perhaps she recently moved to the University of Oxford. But nonetheless, her position is that she's the British Academy Global Professor at the University of Oxford, and she's also the co-director of the Max Planck Institute for Comparative and Private International Law. Her research interests include Islamic studies, Jewish studies, historiography, critical theory, decolonial theory, secularism, and Orientalism. Suggested readings include The Beginning of Islamic Law, Late Antique Islamicate Legal Traditions, published by the Cambridge University Press in 2016. Understanding the Sources of Early Modern and Commercial Law, Courts, Statutes, Contracts, and the pardon me, that's not her book. Next book, The Good Orientalists in the Westernist, Critical Reflections on Spatio-Temporal Construction of the West, edited with Christopher Gogglet, Holt Mayer, and Sergei Sistiaga, published by De Gruyter Oldenburg in 2022. Logos include, we have Harvard Law School, where she received her Juris Doctor. We have the University of California, Berkeley, in the bottom left, where she received her PhD. The top right, we have Tel Aviv University, where she perhaps is currently teaching or will return to, and the University of Oxford, where she is currently located. Once again, her chapter is in part 4 of the Oxford Handbook of Legal History, titled Traditions Tracing Legal History, and it is chapter 40 of the Oxford Handbook of Legal History, titled Historical Research on Islamic Law, by Lena Salaymeh. The 3 quotes we have here are, firstly, Islamic law is not a self-evident category of analysis. Defining and understanding the category is a subject of both academic and popular debates. The debates reflect a long history, more than 1,400 years, broad geographical expanse, and extensive demographic diversity of the Islamic legal tradition. Next, second quote, historical research on Islamic law is a burgeoning field facing many of the political and normative challenges of scholarship in Islamic studies generally. It would behoove this field to confront these challenges more directly, both by acknowledging them and by recognizing how they influence the contemporary writing of historiography. Third and last quote, with a wide array of sources and questions that have not yet been investigated thoroughly, historical research on Islamic law is a field that will continue to grow and transform in unpredictable ways. So I think a beautiful chapter and a great introduction to Islamic law, and perfectly well placed in comparison with Islamic law by Stephen Wilf. And once again, this chapter by Lena Salaymeh. So moving to the comparison of Stephen Wilf and Lena Salaymeh in the style of Plutarch's Lives. The justification for this is in the style of Plutarch's Lives. I think by having these comparisons, it really determines a little bit more about who these people are by finding out, I guess, where their boundaries are or where they differ from other people. But for all these comparisons, these authors are more similar than they are different, from both being included in the Oxford Handbook of Legal History. But nonetheless, we shall begin. So Stephen Wilf has a Juris Doctor and a PhD from Yale, and Lena Salaymeh has a Juris Doctor from Harvard and a PhD from the University of California, Berkeley. So quite somewhat similar, both educated in the United States, but nonetheless studying laws from the old world, at least in the course of this textbook. The Islamic law and Jewish law are both sort of centralized in the Middle East, but nonetheless they're both educated in the U.S. Not to say they're necessarily born in the U.S. That was hard to determine. Actually, I believe Stephen Wilf might be from Philadelphia, but I'm not certain. But nonetheless, they're both United States educated. But it might be noted that Lena Salaymeh did her PhD at a different institution as she did her Juris Doctor from. So small difference there. So therefore, we might note that Lena Salaymeh has studied on both in New England and in California, whereas Stephen Wilf received his PhD and Juris Doctor in New England and also stayed in Connecticut as well. So stayed in New England. So both U.S. educated, and they both have a Juris Doctor and a PhD, which isn't necessarily true of all the scholars in this textbook, or all scholars generally. Sometimes, often it's most lawyers or people who receive a Juris Doctor in North America do not have PhDs, and most PhDs do not have law degrees. So definitely more similar than they are different here. And clearly there's differences between Yale, Harvard, and UC Berkeley, which I think one can deduce on their own. In terms of their institutions, Stephen Wilf is at the University of Connecticut School of Law, whereas the Anthony J. Smith's Professor of Global Governance, so he has stayed in the United States, whereas Lena Salaymeh is either at Tel Aviv University or Oxford British Academy Global Professor, so she has left the United States, at least for now. They are both seem to be quite entrepreneurial in that Stephen Wilf is the founder of the law school's intellectual property program, and as well, in 2010 to 2013, he was the Associate Dean for Research and Faculty Development, and whereas Lena Salaymeh has co-directs the Max Planck Institute for Comparative and Private International Law in Hamburg. So also lots of traveling to be noted in Lena Salaymeh's case. It might be noted that Stephen Wilf clerked at the United States Court of Appeals Second Circuit, which is something that is a very challenging position to get, whereas it's not clear that Lena Salaymeh has clerked somewhere, so that is something different. So at least, but it seems that neither of them actually have significantly practiced as lawyers. However, in terms of practical experience, Stephen Wilf might have a slight edge here, having clerked for the United States Court of Appeals Second Circuit. However, that period is only for, I believe, a year, so that is still not too long, but it's possible he might have practiced for more, and it's possible Lena Salaymeh has practiced for many years too, but as far as I know, minimal or no time practicing. But they've dedicated most of their time to academic careers and hence pursued PhDs instead. As far as I can see, or can find, Stephen Wilf has 2 books and 15 papers, whereas Lena Salaymeh has 1 book and 26 papers, as well as 3 reviews and 1 edited book. So similar number of books. Maybe Stephen Wilf has a little bit more in the books territory, and Lena Salaymeh has a little bit more in the papers area, but nonetheless quite close in that realm. Stephen Wilf was a Fulbright Schumann Scholar at Centre d'études internationales de propriété intellectuelle in Strasbourg in France, and Lena Salaymeh is a visiting positions at École pratique des hautes études in the sciences religieuses, PSL, so they both have experience working and studying or researching, in France. Stephen Wilf is currently completing a history of intellectual property law with the Cambridge University Press, whereas Lena Salaymeh was British Academy Global Professor at Oxford, so both have experience in the UK, or at least publishing with the UK, but whereas one is Cambridge, the other is Oxford, but nonetheless there's a lot of overlap, especially at the highest echelons. Stephen Wilf has a little bit more focus on copyright, trademark, and intellectual property, so more commercial aspects of law, whereas Lena Salaymeh has more focus on critical theory, gender, sexuality, nationalism, military, security, and foreign policy. And it might be noted that, at least in Lena Salaymeh's areas of expertise, it does include Jewish law, but in Stephen Wilf's areas of expertise, it doesn't necessarily include Islamic law. But nonetheless, they're both fascinated clearly in history, law, and religion, for being chosen as the 2 flag persons for Jewish law and Islamic law, respectively, in the Oxford Handbook of Legal History. So amongst all the scholars in the world, these 2 were selected by Marcus D. Dubber and Christopher Tomlins to write these chapters. So I think a very, very important role they have both played. And clearly from the 2 texts, Stephen Wilf's chapter on Islamic law was, I would say, more focused on the works produced by many of the Islamic Jewish legal scholars throughout history, whereas Lena Salaymeh was more focused on how the West has studied Islamic law over different periods. So very different styles, but both were generally chronological, but one was sort of from a present stance. Lena Salaymeh's was from a current stance, how we have looked at history throughout time, whereas Stephen Wilf was more traditionally historical, as how sort of the people and texts or works and also oral history has shaped it, so more sort of direct from the standpoint of history itself. So 2 different styles, but nonetheless I think it's perfectly that these 2 got paired. So I thank very much the authors, Marcus D. Dubber and Christopher Tolmans, for producing this, or editing this great textbook, and I thank very much Stephen Wilf and Lena Salaymeh for producing these two very fascinating chapters on Jewish law and Islamic law, respectively. So thank you so much for watching and or listening to this lecture, and I hope you continue to support. My name is Kalen Ashcroft, and this is Cashcroft TV, and thank you very much again.